I have one from. Ironically, I have the exact same cups at my house in Toth. I was like, wait a minute. It's not quality.
All rise. Oyez, oyez, oyez. The United States Court of Appeals for Veterans Claims is now in session. The Honorable Margaret Bartley presiding. All who have business before this court draw near, and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good afternoon, everyone. I'm Judge Bartley, and I'm joined today for this en banc argument by, on my left, Judge Greenberg, Judge Meredith, Judge Falvey, and Judge Jaquith. And on my right, Judge Pietsch, Judge Allen, Judge Toth, and Judge Laurer. And we're here today for the matter of James M. Kernz versus Dennis McDonough, docket number 20-2365. Counsel for the parties, beginning with Secretary's Counsel, please state your name and your appearance for the record.
Good morning, Your Honors. Nicholas Esterman for the Secretary, and with me today is Megan Kral. Thank you.
Welcome, Mr. Esterman and Ms. Kral. And Appellant's Counsel.
Good morning, Your Honor. Adam Luck appearing on behalf of James M. Kernz.
Thank you, Mr. Luck. As you know, each party will have 30 minutes and we'll add time as necessary. Mr. Esterman, would you like to reserve time?
5 minutes, please, Your Honor.
Okay, very well. And Mr. Esterman, you may proceed.
Good afternoon, Chief Judge, Your Honors. May it please the Court. The Secretary maintains his position that the notice letter at issue in this case is not a final decision of the Board. Because it is not a final decision of the Board, this Court does not have jurisdiction over this appeal. And because there's no jurisdiction, the request for class action is moot. And we respectfully request that this Court dismiss the appeal and find the dependent request for class action moot.
Mr. Esterman, let me just interrupt you there. What is the status of Mr. Kernz's administrative appeal right now? Is the Board waiting to adjudicate the merits, or what's happening there?
Yes, Your Honor. Consistent with the declaration that we filed a week or so ago, the Board confirmed that Mr. Kernz's appeal has been docketed, and docket order consistent with the 10-182 being timely determined, and his appeal is pending, and docket order consistent with the Board's statutory and regulatory.
Oh, okay. So it's pending in docket order. So the Board is not holding it right now.
No, Your Honor.
Okay, gotcha. Thank you.
And could I just follow up with one detailed question about that? When the Board corrected its error in the May 2020 letter and docketed the appeal, did it, I just want to confirm, it docketed the appeal with the date that the appeal would have had it been accepted as timely originally. Is that right?
Yes, Your Honor. And I think the declaration that we submitted confirms that there is some discrepancy with the date as to when it was received, the 15th to the 17th, and I believe it's January 17th of 2020. So that would be the docketing date, and there's been a docketing number associated, or a appeal number associated with that.
Thank you.
How long is it going to take?
Your Honor, I don't have a good answer for that.
Okay, your experience, can you estimate based upon your experience or consultations that you've had with the appropriate people?
My consultations with the Board, they've confirmed that it remains pending in docket order.
Well, but my question is, how long is it going to take to get a resolution for Kernz?
I don't know, Your Honor.
How old is Kernz? Do you know?
I don't know, Your Honor.
Go ahead.
I welcome any other questions.
Mr. Esterman, is there any doubt that the Board, in correcting its determination regarding the timeliness of the 10-182, was revisiting the exact same issue that's up here on appeal? Or before us right now, I should say.
No, Your Honor. My understanding of the Board's decision to find it timely, given the clear error on the face of the letter, was consistent with the Board's understanding that it wasn't a final decision of the Board, and therefore, because it wasn't a final decision of the Board, the jurisdiction hadn't attached here at this Court.
But the Board's actions were to correct what they believed was untimeliness, and we are reviewing the timeliness issue right now.
Well, Your Honor, I'm not sure we refer to the merits of whether or not it was untimely or not, but there's been a concession in this case that it was timely, but deemed untimely. I think truly the threshold question here is whether or not that initial letter is a decision of the final decision of the Board within the Court's jurisdiction.
And that's been the basis of the Secretary's argument all along, right?
Yes, Your Honor.
The Secretary has not previously argued that the case is moot because the board later docketed the veteran's appeal.
No, Your Honor, our principal argument here is that notice letter is not a final decision of the board, and as such is not within 7252 jurisdiction that this court historically recognizes.
And in accordance with that view, you didn't argue mootness in either the motion to dismiss or the reply to the veteran's response, but only in connection with the request for class action. And even then, it was, as you said, moot because there's no final decision of the board.
Yes, Your Honor.
If you assume that this was a final decision of the board for a second, why wouldn't the individual claim be moot? Assuming the board could act and do what it did and corrected its mistake.
Well, I think under those circumstances it could be moot. Just to confirm my position, our principal position again is that this isn't a final decision of the board. I'm going to sound like a broken record probably here today, but I think effectively, especially for Mr. Kernz, any possible relief that he could have received if that wasn't the case, and this court did have jurisdiction, has already been provided to him by way of docketing in terms of docket order, as well as providing him the option under the evidence submission window that he requested. So he's been made whole.
So do we have to, you keep going back through the final decision angle to get to the mootness, but do we have to even reach that? If whether the letter is or is not a final decision, Mr. Kernz has been provided, there's nothing more he's asking of this court than what he's already been provided. There is no live controversy anymore.
I don't disagree, Your Honor, and that's been the case since before the request for class action was filed in this court. This has been moot since May of 2020, I believe, prior to even the Secretary filing the July 2020 motion to dismiss.
Assuming, of course, that the board could take the action that it took, given Cirillo.
Correct, Your Honor. Yeah.
So I don't want to cut off my colleagues' questions, but I'm interested in hearing why we wouldn't view that action as just void because of Cirillo, and ask you also if it's not void, do we need to overrule Cirillo to get there?
I take the first part of your question about the applicability of Cirillo, and I think Judge Jaquith and I had this discussion last year about the distinguishing circumstances between Cirillo and this case, and I think the fundamental component and the court's holding in Cirillo is that the court held that it has its jurisdiction attaches when there's appeal of a final board decision, because whether or not this notice letter is a final board decision is in dispute. It was our view that Cirillo didn't apply and that the board was able to take the action it took. And throughout the Cirillo decision, finality and final board decision as contemplated by this court's statutory framework is reemphasized over and over again. So that is the basis for the board's action here and why we didn't think Cirillo applied.
So do you agree that if the board issues a final decision and a notice of appeal is filed, the agency may not divest the court of jurisdiction by unilaterally reopening its administrative proceedings?
Absolutely, Your Honor. If this was, in our view, a final board decision, the secretary and the board would have taken no action.
So if,
Go ahead.
assuming that the March 2020 letter is a final board decision, I want to follow up on the Cirillo point. First of all, what are the May and August letters? If the March 2020 letter is a final board decision, do the May and August 2020 letters impact it at all? Were they reconsidering it? Did they try to vacate it? Or do they have any legal significance of their own, the two follow-up letters?
That's an interesting question, Your Honor. In our consultations with the board, I don't know if that has come up. I think the actions that were taken in May and August were consistent with the view that that wasn't a final decision. So unfortunately, I'd have to speculate as to how the board would view those two determinations. But I acknowledge, though, that at the point that those actions were taken, if this was a final decision, a notice of appeal had already been filed to this court. And as Judge Jaquith just mentioned, our position would be at that point, if it was a final decision, that jurisdiction would lie with this court.
So if we were to apply...
Excuse me, can you talk a little louder? I've got kind of old ears.
I apologize, Your Honor.
that good at lip reading.
I have a little bit of an echo here as well, so okay.
Yeah, I was just going to actually say the same thing. If you could, I don't know, get a little closer to the mic or. Great.
I'll try my best. Is that a little better? Thank you.
So, following up on the Cirillo question and as to whether the court, if we strictly applied Cirillo, would that require the court to void or nullify the actions taken in the May and August letters? So literally tell the board not to docket Mr. Kernz's appeal.
Assuming that.
Go ahead.
I apologize. Assuming that this is a final decision of the board, yes, I think the court could take that action, but as a practical matter, it's already been docketed where it would be, and the relief has been provided. So I think there is some tension there in terms of what the relief that the court could provide Mr. Kernz.
Speaking of the tension, how would voiding? So in our appellate context, we have constraints about. We generally review adverse determinations, and we generally only review the record of proceedings up until the time of the board decision on appeal, which here, the purported decision on appeal is March 2020. So what authority do we have to undo favorable actions taken by the agency, favorable actions after the date of the purported board decision on appeal?
I'm going to be honest, Your Honor, I'm not sure I have a good answer to that question, other than the Secretary respects the precedent as set in Cirillo as it applies to final decisions of the board. And that is the predicate for our position throughout this case since 2020. I'm not quite sure. Obviously, I'm sure the court has authority to decline to impact any type of favorable action taken by the board.
Just one more question about the March 2020 letter. What would be the most veteran-friendly outcome of whether that letter is a final appealable board decision or whether it's just a letter? Does it have any independent legal significance if it's just an errant letter? And what are the procedures for a veteran to undo a letter as opposed to if it is a final board decision? Does that put them in the category where they have to follow up with motion for reconsideration, motion to vacate, or appeal to the court? But what are the different procedures we would follow if it's just a letter?
Well, Your Honor, I appreciate that you use the pro-veteran terminology because I think hopefully the actions that the board has taken and the Secretary's position here has been viewed as pro-veteran, especially with respect to Mr. Kernz and subsequently impacted veterans. As far as how this would play out down below, our view is consistent with the discussion that the Chief Judge and I had last year, that we view this as an initial determination that allows the veteran one right of an appeal to the board to have a VLJ determine the merits of the timeliness determination, which can then be appealed to this court. And that construct has changed slightly since the legacy system or in the modern system. That's why the board is now doing those initial docketing determinations. And so I think if that was the case, then we would potentially be depriving the veteran of that one right of a review on appeal by having a direct appeal to this court.
But there was no indication in that letter that such a construct existed, was there?
I'll admit, not clearly, Your Honor. That letter did provide, it does have a heading that says if you disagree, and provided some avenues.
If you disagree, you can seek an extension of time.
Yes, Your Honor.
Mr. Kernz look at that and say, I don't need an extension of time. My appeal was timely filed.
Yes, Your Honor.
No potential remedy offered to him.
And I don't disagree with that. But, the board has taken action to amend that letter to quite clearly provide that appellate avenue. And as I noted last time we were here, the AMA is attempt to streamline. It's a drastic change in how we adjudicate claims that dates back decades. And so there are some growing pains here, and this is one example of a growing pain. And I hope that the board and the Secretary's prompt action to try to remedy this problem is viewed favorably by this court.
Yes, but since it took until August of 2021 for the board to provide notice and a remedial process for veterans like Mr. Kernz who had their timely board appeal mistakenly rejected due to a calculation error, how would the board have realized and addressed this error if not for this appeal?
I don't disagree, Your Honor. As we noted last time, I think Mr. Kern's attempt to appeal this letter did highlight a problem, but that problem also could have been highlighted by informally contacting the board and saying, hey, this is untimely, and I think it's wrong. And on the face of this letter, I'll just note that there is a number of problems. There's a date issue. There's a placeholder dental injury. And so there's a question, I think, open question as to whether this was simply a miscalculation or just the letter was issued in error and a different version should have been issued to Mr. Kernz. Not that it should have any bearing, but this is part of the growing pains I think that we see here. With respect to why it took so long to take that remedial action, we were in consultation with the board, throughout the course of this litigation, and the request for class action that was filed. The date is escaping me, but did impact kind of the progress of how we were handling things and the strategic decisions.
But our case law is pretty clear that even if the error was just a clerical one, involved oversight, some omission, the board cannot unilaterally correct it once a notice of appeal has been filed without following the procedure that Cirillo lays out, right? Asking for permission to do that through a remand motion, joined or not joined by the veteran.
Your Honor, I don't disagree, and I think I do disagree to the extent that Cirillo is premised on a final board decision, and because our threshold position is that this isn't a final board decision, we continue to believe that Cirillo and Lauer and its progeny don't apply in this situation. And I admit this is unique, but this is kind of the unique new circumstance that's a product of the AMA and how these determinations are made at the board, and there is a little bit of growing pain here.
Well,
even if you don't believe that Cirillo applies here, once you realize that the veteran filed an NOD and we were going to look at the issue, you filed a motion to dismiss, we were going to look at the issue of whether it was a valid board decision, a final board decision. Why did you then go and keep acting as to his on his case down below when you knew that we were looking at the issue?
Yeah. Well, 2 points, Your Honor. First, our fundamental position is this isn't a final decision of the board, and so this court's jurisdiction 7252 and 7261, 7266 with the final is predicated on a final board decision.
But we hadn't acted on your motion to dismiss, which was based on that very point.
Correct, Your Honor, but there also was...
So that issue was before us.
But there also was no final board decision in our view. And so that's why we took that action. I can understand the concern about the action that was taken. But again, I think there's maybe an analogous situation is sometimes we see veterans file rating decisions or notice of appeal on a rating decision, an SOC to this court. And simply because there's a notice of appeal filed in those circumstances doesn't mean that the agency stops working on that claim down below. And I think this falls into a very similar circumstance that when it's clear, at least to us, and I understand there's a dispute as to whether this is a final decision of the board, but when it's clear in our mind that it's the veteran-friendly approach would be to continue to act to further that claim. And in this situation, Mr. Kernz was made whole by having his appeal docketed in docket order and having the elections that he sought under the AMA provided to him.
What's the normal method that the board dismisses untimely claims? How does that normally happen?
Well,
so if they say an NOD is filed late and this claim's untimely, so they don't have a duty to adjudicate it, do they just communicate that in a letter?
Assuming that we're talking about the AMA system?
Yeah, either one.
Sure. Well, the legacy system would be done at the AOJ or the RO, but the board, I think the declarations kind of go into detail of this, but it goes into the intake office. That NOD 10182 is opened up. Administrative professional determines whether it's timely or not, right? That's binary. The 60 days of the year, depending on the type of opt-in or whether it's a pure AMA appeal. And if it's determined timely, it just gets docketed. And that's, I think the majority of the time, that's what happens. But to your question.
Yeah, so what if it's untimely? What if 2 days late?
If it's untimely, then the board issues what now is the revised letter that says you can seek an extension for good cause if it's truly untimely, or you can seek, And what if?
And I appreciate I'm asking you to do a little bit of a hypothetical. What if that's actually a calculation error? What if it turns out it's timely and the veteran wants to sort of challenge that? Why would that not be something, why would that not be, in a sense of, if the board did not allow the veteran to challenge that, why would that not be a final determination? I mean, it's that it concludes the case on procedural grounds. It involves at least the application of law to fact. Why would that not be a decision?
Well, Your Honor, I can appreciate that. As we've argued since the outset, this letter, in our view, is not a final board decision that's appealable to this court, but also was never intended to be a final board decision. And
I know that 2801, I think it sets out some requirements for the form of a board decision. I mean, is your argument that unless something fits the formal description of a board decision, that even though it involves a communication of a legal determination that's adverse to a veteran, that it could not be a final board decision just because it doesn't meet the form of a board decision?
No, Your Honor, but I think, as we're probably both aware, that the 95, maybe 99% of the appeals to this court come in a very similar form, board decision, how we treat it. And so this letter does not come anywhere near that form. No appellate rights, no 20.801, no 7104.
Right. I understand the form. I'm not disputing that. But there's substance in that letter. And that letter, I understand the corrective actions taken later speak to the mootness, and they may address it. But, I mean, again, if you assume that there had been, maybe if you assume the agency never changes its position and they maintain that these are late letters and the appeals would be dismissed, why would, I mean, there's a lot of substantive law there. I mean, cases get decided on procedural grounds. You can dismiss a case on procedural grounds.
Yep. I guess my second point would be, and I think I just mentioned this to Judge Bartley, that, or maybe one of the other judges, I'm sorry, that our view is that if this was directly appealable to this court, that letter, that initial determination would be depriving the veteran of one right of review at the board. And arguably that may be more efficient and cost effective to have the board possibly correct a timeliness error there. And so if this was directly appealable, as we've said in our early pleadings, I think that's quasi-interlocutory, as well, to deprives the veteran of that one right of review on appeal.
So, Mr. Esterman, is it your view that the communications, the additional letters that you've given the veteran now comply with 20.104C?
I think if the court was to determine that 20.104C applies, yes, those communications do resolve that issue.
And how do those communications comply when C requires that the veteran or claimant will be given notice of the potential jurisdictional defect, granted a period of 60 days following the date on which such notice is mailed, to present written argument and additional evidence relevant to jurisdiction, and this is the part I want to emphasize, and to request a hearing to present oral argument on the jurisdictional question. So it says you will be granted the opportunity to request a hearing to have oral argument on the issue. Was he given that? Did any of your letters mention anything about that?
2 points, not that I'm aware of. And I think that contemplates a situation where, in this situation, I think those actions, for lack of a word, I understand, our regulations would be extraneous because it was a calculation error that the board was simply able to look at in the four corners of the decision and say, this was timely and able to dock it quickly. So if additional argument, I don't know if it would have changed that. A hearing necessary wouldn't have changed that. But I said, if the court was to find this regulation apply, I think effectively we have complied. But as we noted in the last argument, this determination in our view is not jurisdictional. And it's not jurisdictional consistent with Henderson because the regulation and statute allow for an extension of time for good cause. And as the Supreme Court found in Henderson, when there is an extension for a good cause, it's not jurisdictional, it's not timely or not timely. So our view is that the timeliness determination here was not jurisdictional, such that 20.104C wouldn't apply. But if the court believes that 21.104C does apply, then I think we have effectively complied with that in terms of promptly docketing the appeal and finding it timely. there was no argument necessarily that would have resolved it other than saying, I think you have miscalculated this. And that was obvious on the face of the decision.
Well, I don't know. It requires three different things, and you only apparently gave them two. But
Did you say that it was extraneous, the other elements that the Chief Judge referred to?
That
Did I understand you to say it's extraneous?
for lack of a better term, Your Honor. But my point just being that given that we were able to dock this as timely, it was just a calculation error. Providing additional argument, providing a hearing here would have just delayed that determination necessarily.
Is this part of the growing pains you described earlier of the system?
Yes, Your Honor. I think.
Well, why should the veterans suffer the growing pains of this enormous administrative apparatus you have here? And are we not in a position to correct it?
I don't think you are, Your Honor. I think this is not a final decision of the board that falls within the court's jurisdiction. So
you haven't deviated from that single argument that you've been making?
I have not, Your Honor.
Thank you.
Mr. Esterman, with respect to the corrective measures that the agency took in the letters of May and August of 2020, what specific statutory or regulatory authorities is the board relying on for doing so?
Your Honor, I'm happy to answer, but I look like I'm about to run out of time.
Let's add 10 minutes. Thank you, Don.
Your Honor, I'm not aware of any specific statutory or regulatory authorities the board used to correct that. I presume, as maybe Judge Meredith was alluding to, that there is some regulatory avenues to correct a clear and obvious error that the board made. But again, this is not a final decision, so it really was a procedural clerical error that the board was correcting. So I don't know if there's necessarily a statutory regulatory basis for that, other than being pro-veteran in nature in terms of docketing an obvious calculation error.
Okay. I mean, so some changes were made to the template that's now used, but no consideration given to perhaps looking at additional statutory or regulatory authority to be able to do that, absent what you would consider a decision, a board decision.
Maybe I misunderstood Your Honor's question. Is it with respect to the change in the letter itself or the corrective actions?
No, the corrective actions, but they're related to each other.
Yeah, the board did amend its letter to make it clear as to the avenues available to a veteran. I'm not aware of any type of statutory or regulatory authority that allows them to change the letter other than the broad authority that in the concept of claims processing that the board and the court can take actions to make sure the efforts and their daily procedures function effectively.
Could I just follow up on that? I just want to make sure which of the two issues you're talking about here, Mr. Esterman. That is the corrective actions, I'm assuming, in my mind, are the May and August 2020 letters directed to Mr. Kernz, basically saying, we were wrong and we've redocketed your appeal as if it had been timely at the time, right?
Yes, sir. I think that we have corrective and remedial measures. But
right, and so the first question I understood Judge Laurer to be asking is what authority might have allowed the board to do that? Let's put that aside for a second. The second question, as I understood it, was the broader corrective action, which is now changing the template, if you will, and saying the administrative professional looks at this, issues the untimeliness letter, says if you disagree, you can ask for an extension, or you can ask for review by a VLJ, right? On that, based on your earlier answers, it would seem to me that the authority would be that under the AMA, the board has to do this, and under the general statute, the veteran gets one right to appeal to the secretary. Yeah. So wouldn't those two things provide support for that?
I appreciate the help, Your Honor. Yes, I don't disagree.
Okay.
That those the broad statutory authority under the AMA and what to comply is what governed that. So there's
and I was just following up because I think that the May and August stuff might have been ad hoc, right? I mean, we found out we made a mistake. We found out we were doing this wrong. But as to the second part, it seems to me, as I understood it, it was whether it's a good enough attempt or not. It was an attempt to now say, oh, we need to, at the board, mimic what existed in the legacy system with the RO doing it first, then going to the board. Now we have to craft into this what the AMA said. Now we move to the board. Am I generally in the ballpark on that one?
I think you're spot on, Your Honor. And that's consistent with, unfortunately, the growing pains that I think this transition has had. The board has never had to receive these NODs before. That was something that AOJs and ROs did. So it's a significant structural change.
And while I have you, are you aware of that there are decisions out there in the other federal courts where even though a case cannot be at two places at the same time, for purposes of my question, assume that this is a final board decision, the March letter, okay? I understand your opinion is on the record that it's not. But but there are decisions out there in the regional circuit courts of appeal in which even though a case can't be in two places at the same time, when the agency, they're usually agency cases, actually takes a step, even though they shouldn't take the step, because it can't be there if it's in the Court of Appeals, but takes a step that moots the controversy under Article 3, the courts will dismiss the appeal because there's no controversy left, even though they couldn't do that. Are you aware of those cases?
I'm loosely aware of those cases, though I don't have them necessarily with me. But
so wouldn't that suggest that in this case, since we've adopted the Article 3 mootness requirements, that even if Cirillo clearly said that the board could never take the action it did, why wouldn't it be the case that if it truly granted Mr. Kernz everything that the court could ever grant in a judicial decision, that as Judge Pietsch's memorandum decision in a case called Percivali concluded, the controversy is moot?
Well, I don't disagree. I acknowledge that I think Judge Pietsch's memdeck is on appeal to the federal circuit, but I'm aware of that opinion, and this situation is exactly that. There's no further action to be taken. Mr. Kernz has been made whole, but I think a lot of factors in this case have complicated the request for class action, and I'm sure as you're aware, there's a number of cases that are stayed pending this case, and I think our fundamental position about jurisdiction is something that I think a lot of people would seek clarity on as to whether a notice letter is a final decision of the board. So that is why our emphasis is on that issue. But if the court was to deem this moot by action of the secretary and the board, I wouldn't disagree with that.
Mr. Esterman, as regards the cases that Judge Allen is referring to, aren't they mostly cases that deal with the transfer of jurisdiction between a district court and a circuit court, or a trial court and an appeals court? And here we have transfer of jurisdiction. VA is the adjudicator down below and is the other party in this case. Does that complicate matters? How do you see that impacting what we're doing here?
I hadn't thought of it that way. That is a unique difference between the district court and the appellate court and VA and this court. But I think the other significant difference, though, also is that this court's jurisdiction is predicated on exclusive jurisdiction to review final board decisions.
You're right. You're beginning to sound like a broken record.
Yes, I apologize, Your Honor.
But I'm just teasing you.
I just have to say it. But yes, so I think that's the fundamental difference. District courts have plenary jurisdiction, and that transfer is slightly different here. You have limited subject matter jurisdiction, and I say that with all due respect. And because of that, I think there's fundamental differences. And again, our position being that because it's not a final board decision, that Cirillo doesn't apply here, given that that's ultimately what that Cirillo is predicated.
But otherwise, you don't question the sanctity of Cirillo?
Not in the presence of a final board decision, Your Honor.
So, are you okay with the Secretary's view that the Cirillo Court's declaration that deferring to unilateral action by the board would give VA the power to defeat meaningful judicial review? Is that...
Cirillo speaks to that, Your Honor, but the fundamental holding in Cirillo is that is based on a finding of a final board decision. I'm sorry, Your Honor, but that is not, in our view, what we have here. So, in the presence of a final board decision, I can't want to promise on the record, but we generally do not take action in situations where there's a final board decision. We wait for the appellate process to play out here with respect to the court's with respect to Secretary 72, Section 7252 in the court's jurisdictional statute. But here, in our opinion, we don't have that final board decision.
Yeah, but especially in a circumstance, as you described it, of growing pains, why is the secretary's first reaction to attack the court's jurisdiction when there's been a valid or a notice of appeal without engaging with the court, following the Cirillo process and asking for the cases that Judge Allen refers to mostly involve the lower tribunal signaling, look, this is what's come in. Here's what we do with it if you will let us. Why isn't that what happened here?
I'm just going to note that I think I'm going to run out of time before I finish your answer. But
Let's add another.
And I apologize, I lost the fundamental point of your question.
Why didn't it happen here?
Yeah, why is the initial reaction in
thank you.
a case of the process is in its infancy and on uncertain footing, especially in those circumstances? Why is the initial reaction to attack the court's jurisdiction rather than acknowledge the process in Cirillo, and by which you've acknowledged you're very familiar with, and ask?
Well, again, our position with respect to Cirillo is predicated on something very specific and not the final board decision. But we filed a motion to dismiss with the court in July of 2020, raising our beliefs as to the court's jurisdiction and what this letter is not. And that still remains pending with this court. So we did raise the issue very early on in litigation. I believe the notice of appeal was filed in April of 2020. So within 3 months being assigned to counsel in our office, we raised that objection. So I don't think we didn't try to hide from this court. We availed ourselves right away of our position as to the board decision.
But even then, not then or ever, has the secretary ever said, even in the alternative, that if the court disagrees that the March 2020 letter is a final board decision, finds that the March 2020 letter is a final board decision, we'd ask for a remand so that we can take care of the problem.
I think, as I've said a couple times to you specifically, Your Honor, if the court was to find that this is a final board decision, we don't disagree that Cirillo would apply, and a remand or settlement might be appropriate as contemplated by Cirillo. But then again, the unique circumstances here is that Mr. Kernz specifically has been made whole by having his appeal docketed. It's been docketed since May and April of 2020. So whether a JMR...
There was a step required after the motion to dismiss to address, the veteran replied, wait a minute, my 90-day evidence submission window has been truncated or maybe even eradicated. So that was the second letter that people were asking you, the judges were asking you about.
Correct, Your Honor.
I want to sneak in some questions about class action, but if there are more questions on this, I'll wait.
Just asked this question before that. Let me take you back to the letter that started this whole thing. And you've admitted that the process is nascent. It was in the beginning stages. So having said that, I see that a vice chairman of the board signed that letter. Was there any quality control done on this letter before it gets signed out? It's an obviously pretty big mistake here, and one not quite really explained. So, but was there anybody that reviewed this letter or did something to it to say, well, this isn't quite right? And we wouldn't be here then.
I'm going to borrow Judge Allen's favorite answer, I think, to this court is I don't know if there's any quality control that's done at the board. I do know that we have mail intake administrative professionals who are the ones that made this determination, even though the vice chairman did sign the letter. They were signing in his capacity in an administrative function. But I'm not sure if there's any quality control done on that. But at least now there's built-in quality control in terms of the avenues that are clearly allowed or provided to a veteran to challenge any determination.
I do have one question about class action. So this is in regards to your, I think most recent, you filed a response to our Be Prepared to Discuss order. So if the amended class that the appellant has suggested would meet all of the requirements of Rules 22 and 23, what would the basis be for denying certification based solely on VA's resource issues or resource constraints?
Your Honor, would you like me to assume that the class definition is specifically identifiable? Or would you like me
Yeah. Yes, I would.
Okay.
I mean, we as you know, we can modify the class so that it fits whatever parameters we see are needed.
Sure, Your Honor. But just to preface, we do have disagreements with the scope of the class here, and I think there's a number of problems.
I understand.
In terms of, but the class definition, and I think as this court's order requests us to be prepared to speak about, and ascertainability are similar and related factors, and I think what the board's declaration speaks to, and not being able to identify people speaks to whether we can identify people that would be in a potential fine class.
Yeah, but in your response, you didn't say that you couldn't identify the people. I thought that you said that it would require a lot of resources.
It would require, yes, Your Honor, it would require a lot of resources, and it would require human resources. And so as there was human error in the calculation of this letter, there is anticipated human error in sequential review of duplicate 10182s and docketing notices. And so the board, I think, is being realistic. I see I'm going to run out of time. I apologize.
Yeah, Don, if you would add 10 minutes, please.
So I think the board was being realistic and not only identifying the resource issues that it has, but also the realistic effects of a manual review of, I think they said since 2019, they've had 400 plus thousand 10182s during the relevant period that we've been talking about. Might be slightly less, but it's still significant.
I get it. And I'm just asking what the legal basis would be for us to deny class certification based on your resource issues.
I think it speaks directly to ascertainability in terms of a defined class, and it would speak to manageability of a potentially identified.
But you didn't say. But you didn't say that it couldn't be ascertained. I thought your point was that it would be very demanding on VA to ascertain.
As Your Honor may be aware, I mean, there is a split among the circuits as to ascertainability, but there are situations where a class can be so large that there's difficulty ascertaining an adequate class. There can be situations where the factors or circumstances of potential class members could be difficult, and those are also circumstances that I think this court should also account for and would reasonably account for the resource issues that the board has outlined.
Right. Well, I guess very few circuits seem to follow the administrative feasibility track. So, just saying.
Yeah, but the Third Circuit historically for quite a bit, and I feel like the Fifth Circuit as well. And I will note that in Constantine, this court seemed to recognize the relevance of ascertainability in a footnote in the BMW case and a subsequent case from the Fifth Circuit. So, we view that as something the court seems to be interested in entertaining.
Thank you.
VA could have provided a number reflecting the difference between the appeals received and the appeals docketed for a discrete period, couldn't it?
I haven't asked the board that, but assuming that they could provide a number of 10182s received during a specific period and the number of docketing appeals that they received during that period or docketed during that period, as they noted in their declaration, the use of 10182s can sometimes be used informally to communicate information. There's duplicates in there. I'm sure as this court is aware, when you look at a record, sometimes you have a faxed NOD, you have a mailed NOD, you have an electronically transferred NOD. And so that is ultimately what the board is talking about in terms of the difficulties and the resource-intensive nature of trying to identify this. So
but the deputy vice chairman's implication was clearly that we could do this. We don't think it gives a reliable estimate, but we could do it.
I may be paraphrasing, but I believe he used the word impossible at one point. And
no, I mean they could get that number. They could get the difference between appeals received, appeals docketed, and then he goes into an explanation as to why he wouldn't think that the difference would be necessarily reflective of the class.
Yes, I
It
don't.
would certainly narrow the prospective class from, I think, the number of 10182s within the relevant time period is more like half of the 400,000, but would cut that down from 200,000 whatever to some number much less.
Yes, there may be a way to narrow the number, but I think the accuracy of potentially impacted claimants would be difficult to ascertain. And not to minimize the scope of this problem, but we did have the notice. We've had it out for almost 2 years now, and we've received 15 responses and 5.
But doesn't the March 1st, 2022 deadline in the board's notice invalidate the notice? Or put another way, isn't the assertion that the board will continue to honor requests for recalculation received after that deadline meaningless and misleading, since the deadline continues to appear in the notice? It's not a surprise, is it, that there have been no more responses since March of 2022 when the notice says we're only taking them from March till March of 2022?
And to speak to the court's question on the deadline, there's no regulatory statutory authority for setting that deadline. It was meant to encourage responses while the issue was fresh in the board's mind, is my understanding, and they had staff trained before they rotated onto other details. But
instead it provides an imaginary roadblock.
But I think there's two ways to look at that, Your Honor. One, there could have been a chilling effect as to responses after 2022, or the response that we received is indicative of kind of the narrowness of this issue, which we hope is the case. And given the 15 responses we received, only 5 were identified calculation errors, and those were quickly docketed. But I will submit that I believe the board would be willing to remove that deadline from the notice if the court thought that was helpful, but reluctant to do so given the en banc nature of this case.
In the absence of any effort by VA to ascertain the number of veterans similarly situated, why shouldn't we certify the class based on the veterans estimate?
Well, Your Honor, I think certifying simply on there's a number of factors that go into certifying a class, and I think we disagree with a number of the factors in play here, which I'm happy to discuss. But I think just simply on the estimate would be overly broad in terms of as it relates to the class definition as well.
So,
and I apologize.
Go ahead.
And may speak to if the court was to find this to be a final board decision, that there is a problem that the court needs to address in a decision, maybe a situation where a panel decision of this court, or en banc decision of this court, would be superior than a class that may be difficult to manage or ascertain.
Isn't this the worst possible situation for the veteran? His case is rejected. It's not even docketed, so he has no opportunity to get benefits, and no one would even know that he'd been cast into the abyss if this appeal hadn't been filed and accepted by our court.
Yep, I agree, Your Honor, and that is why I think the Secretary and the board are at least thankful to Mr. Kernz for raising this issue, and why we've taken prompt remedial efforts to try our best under the circumstances to provide a remedy and an avenue for these corrections. But it is a unique case and something that we hope is not repeated.
You think that the facts as presented as of now represents the best efforts of the Secretary to correct this?
Yes, Your Honor.
You just indicated that you may change the letter this March 22nd. Do I have the right date? 2022 letter?
The exact date.
The cutoff date. In other words, here's my simple question.
Oh, the notice, yes, Your Honor.
Why couldn't a normal, reasonable, rational veteran look at that letter and say no is no if it's after that date? You're suggesting, well, maybe if you get around to it and you think it's the right thing to do, you'll change that date. Couldn't that account for the lack of hundreds, thousands more veterans making their notice of appeal or asking for permission to be part of the class?
Your Honor, I would only be able to speculate as to the number of other impacted claimants. But
isn't that speculation exactly that? Why should this veteran or the class of veterans suffer because all of these errors were made by this department? And the only action that I can see this department taking, following to some of my colleagues' questions, was to come here and say, we don't have jurisdiction to correct it. You haven't done any of the interim things that you're suggesting would have been available to the secretary. Why not? You get 1,200,000 appeals a year. You deal with all of those. Very few come here. So why not just take the course that you now think is prudent or available, as well as challenging our jurisdiction?
Your Honor, I think that's what we did. I think we took corrective action.
Well, wait a minute. You docketed Kernz's appeal, and you say that's enough to satisfy him. How long is it? My first question an hour ago was, how old is he? How long is it going to take?
Well, respectfully, Your Honor, I think that's a separate concern outside of, that speaks to the merits of.
Well, with great respect, it's my concern.
I understand, Your Honor.
What about the class? You have any idea who's part of that class? Minimal?
As the board is.
How many?
No, Your Honor.
Thank you, Mr. Esterman. And Mr. Locke, you may go ahead.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court.
Mr. Locke, would you please speak up some, or maybe hold the mic? Thank you.
Is that better? Can you hear me now?
Not better.
Outside voice.
Don't be afraid.
Be very
Speak up.
I'll pretend I'm talking to my children. There's no dispute that the board acted unlawfully in this case. So the issue is not whether the board erred, it's the remedy and what should be done about the men and women like Mr. Kernz, whose appeals were unlawfully extinguished. Mr. Kernz asserts that without this court's intervention, those men and women will be left in perpetual purgatory because their appeals remain closed, and the Secretary has made it clear that he has no intention of locating them and informing them of the board's unlawful actions. Because doing so would just be simply too burdensome. This court has two different options to afford relief in this case. One, obviously as discussed in the pleadings, is to certify a class and award class relief as previously discussed, and the request for class action. Alternatively, Mr. Kernz asserts that pursuant to 38 U.S.C. 7261 and 28 U.S.C. 1651, this court can fashion class-like relief without certifying a class and order the Secretary to locate the adversely affected men and women and notify them that their appeals were unlawfully closed. It's Mr. Kernz's position that the Secretary's motion to dismiss should be denied because the March 2020 dismissal from the board was a final adverse decision that is subject to appeal and falls within this court's jurisdiction. And two, the board's post-notice of appeal actions did not moot Mr. Kernz's claim. And in fact, we're done without proper.
Let me ask you about that, because there was a pleading, I think it was the September 10th, 2010 response to the court order. You essentially said on page 4 that you only took issue with the Secretary's characterization that this was a final board decision. And you agreed that it was otherwise, that the matter was otherwise moot. And that if the court would give you a precedential decision on that first question, you would agree. The rest is moot. Explain that to me.
Well, allow me to clarify, Your Honor. One thing that's come to light in reviewing this case is that the board's
unilateral post-notice of appeal actions has created significant confusion in this case, and that confusion has created the harm, or added to the harm, which is more than just docketing. The harm that Mr. Kernz experienced was a violation of 20.104C when his appeal was rejected. And that's more than a mere docketing, because the board's unilateral post-notice of appeal actions have created 3 separate 90-day evidentiary windows. And pursuant to this court's recent decision in, I believe, Davis v. McDonough, the court made it very clear that if evidence is not submitted within that 90-day evidentiary window, that it will not be considered by the board.
Did you submit during those evidentiary windows?
We submitted during the May 90-day evidentiary window, Your Honor, but not the August window or the January window, because Mr. Kernz believes that Cirillo applied, just as it has in other class members' cases in which the secretary.
Well, that's a lot of, you're at that point, it was being disputed, it was being appealed here, and Cirillo applied, and you're right, then not taking advantage of that 90-day window seems to make sense, but it seems like an awfully big risk for the veteran. If you had something to submit, why not submit it?
Well, that's why we did submit it, Your Honor, to
in the one period. But the other 2 you did not?
Well, correct, because the board indicated that the appeal was docketed as 90-day evidentiary window began. So as Mr. Kernz's advocate, we submitted arguments and evidence during that 90-day window. But then the board took additional unilateral action to say, your 90-day window now begins in August. And so that confusion now results in whether Mr. Kernz's arguments and evidence will be considered, because it was submitted during a 90-day window. But now there are 3 90-day windows.
Okay, so back to my original question, though. I guess your point is that although you said in September 2010 that it was otherwise moot, you're now saying, no, it really didn't moot it because we had other ongoing harms.
Correct, Your Honor. The ongoing harms, again, being the confusion created.
Why wouldn't confusion? Okay, but you're assuming, aren't you, that the board is now not going to consider the evidence that you submitted in the May window? The May window? You're assuming that, right?
Well, this court's recent decision in Davis v. McDonough said that the 90-day window begins when the notice of appeal is received at the board.
Right, and you're assuming that the board is going to look at this and just treat it normally and say the real window is August. My point being, we generally, or any federal court, generally doesn't answer sort of hypothetical harms, right? And so, let's play it out differently. What order would you have the court, leave the class aside, right? So what order would you have the court give?
So the order that Mr. Kernz would seek would do 3 things. One would be to deny the Secretary's motion to dismiss, first and foremost.
Right. I assume we deny the motion to dismiss, and then everybody's treating this as if this whole thing is about whether this is an appealable decision. That's an issue. The appeal is about whether or not Mr. Kernz's appeal was timely. Something that we now know it was timely, right? So they say it's timely, you say it's timely, the board says it's timely. Okay, so what order would we give to the board that already has determined it's timely and docketed it?
It would be to comply with 20.104C and to docket with the proper authority to do so, because Mr. Kernz believes that the board did not have action to take its post NOA.
So really you're saying then that you would want the court to order the board to undo the thing that you filed the appeal to get the court to do, so that we can then enter an order to tell the board to do what it's already done?
Well, if Cirillo applies, then the board's actions were void, so it hasn't done that action yet.
Well, but it has done it in the real world. I mean, it's like Abraham Lincoln, right? As he famously said, if you assume that the tail is a leg, then a dog has 5 legs. But we all know that a tail isn't a leg. We know that the appeal is timely. I mean, that's what makes this a very strange situation. So to get to back to Judge Falvey's question, the thing that you're pointing to about why this is not moot is the 90-day window point and the fact that there is confusion that might in the future lead to some evidence being excluded from the board's consideration. Is that right?
Correct, Your Honor, along with the failure to comply with 20.104C. But those things go hand in hand.
Well, right. I mean, but there's nothing beyond. There's no answer to Judge Falvey's question beyond the 90-day window point that you're making, whether we frame it as part of the regulation or just you're talking about confusion.
Correct, Your Honor. We've discussed about Cirillo, and again,
can I ask you a slightly different line of questioning? I mean, I read Cirillo as fundamentally about what now is 38 U.S.C. 7103, and that it limits the chairman's ability to grant reconsideration. 7104B limits the board's ability to reopen or re-adjudicate disallowed claims, right? Neither of those is exactly what happened here.
correct, Your Honor. But this court's jurisprudence has applied Cirillo in the context of the board taking unilateral action post notice.
Right, but it's, I mean, Cirillo is definitely about the chairman basically, ordering reconsideration while the case is up here. I mean, if a board member sua sponte just wants to redo his or her decision because they don't want to get overruled, I mean, that would be 7104B that would seem to preclude that. Not Cirillo. Cirillo is not it's just a case that cites the transfer of jurisdiction doctrine. I guess the question is, it's not whether we have jurisdiction to act, it's whether the secretary had jurisdiction basically to go forward with the case after this erroneous communication.
The secretary didn't have authority to take that unilateral action. And
jurisdiction is Congress sets out, just court agency, anybody who adjudicates cases. Congress says these are the cases you must adjudicate. That's jurisdiction, but you cannot adjudicate anything that you don't have jurisdiction, right? And so it plays both ways. And so either the secretary, it's a 511, it's definitely a veterans benefits case, so the secretary's got subject matter jurisdiction. What then precludes it? Because I only see three possible preclusions. I see Cirillo 7103, that involves the chairman. No chairman here. I see 7104B, that involves a board member reconsidering a final decision. We stipulate that decision's final. Or the basically Cirillo citing the transfer of doctrine jurisdiction, just a sort of, our understanding of a general court rule that something can't be in two places at once. I mean, is it only the third?
well, yeah, I believe the third is the major component there, the dual jurisdiction that prevents one of the critical elements that Cirillo was concerned with is that procedural chaos. And that's the procedural chaos that Mr. Kernz has experienced and the multiple docketing letters taken after this appeal has been filed. And that procedural chaos resulting from that dual jurisdiction being in two places at once, it can be avoided by compliance with what the secretary and the parties have generally understood Cirillo to mean, in that the board needs permission to act after notice of appeal has been filed. And the parties have engaged in joint remands and settlement agreements and other class actions.
I think there's one, there's 7104, I may be misquoting this. One of them allows the board to correct obvious error, right? I think it's 7104C, maybe. Would this be an obvious error? The board could just correct on its own?
I mean, the error was obvious to us in the beginning.
Sure. Yeah, and that would be, secretaries seem to recognize it as obvious a year later. I mean, that would give them jurisdiction if they didn't already have it, presumably. I mean, would that be covered by Cirillo? Does Cirillo prohibit cases where the secretary wants to correct someone's name or do a ministerial exception or something like that?
Well, I think correction of someone's name or a ministerial error is different than extinguishing an appeal, which is what happened in Mr. Kernz's case. But I do think Cirillo even applies in those obvious error situations, because Cirillo really draws the line between the board's jurisdiction and the court's jurisdiction, and it creates the procedures in which to correct those errors. And those procedures are low. The burden on the secretary to engage in a joint motion or settlement agreement is a low burden. So if it wants to take, if the board wants to take favorable action, even if it's to correct an obvious error or to docket an appeal or to reconsider a case, entering into a joint motion or settlement agreement or even a joint motion to terminate is an easy thing to do. That not only preserves the court's independent jurisdiction and precludes the board from allowing which issues it will let this court hear, but it also provides the veteran with input on what that corrective action could be and a judicial overview over the contents of a joint motion for remand or settlement agreement, motion to terminate, etc. And so all those things counsel towards maintaining Cirillo, even in situations where it might be obvious or easy or the error might be determined, less significant than in Mr. Kernz's case where his appeal was dismissed.
So, counsel, let me follow up on that Cirillo point. As an initial matter, your position is that the March 2020 letter was a final board decision. So what are, in your view, the May 2020 letters and the August 2020 letters? What legal significance do they have? They didn't seek to reconsider or vacate the March 2020 decision. So what legal significance do they have, if any?
I don't think they have any legal significance, Your Honor, because Mr. Kernz's theory is that Cirillo prohibited that post-appeal action. And so those actions, those letters, were void from the beginning and should not have been done without the court's permission.
So if your view is that Cirillo applies and that those actions taken after the NOA was filed here are void, are you asking the court to direct VA to remove Mr. Kernz's appeal from the board's docket?
To remand for the board to comply with the requirements of 20.104C, which would include docketing under the appropriate authority and clarifying the correct 90 days, or even assigning a new 90-day period so that Mr. Kernz can understand the precise start and stop dates and when he can submit arguments.
If the actions are void, though, why, under your theory, we should tell the board now, remove it, don't make a merits decision. If they make a merits decision in the next couple of months, perhaps before we issue an opinion, would that also be void in your view?
I think it would, Your Honor. And I think, I think maintaining that action would be void. Again, preserves this court's independent jurisdiction, it preserves Cirillo, and it avoids that procedural chaos that has happened in this case.
So, if there's no legal significance to anything that the letters that happened after March 20, nothing is prohibiting the court, if this is a final board decision, from going ahead and reviewing the March 2020 board decision in your view. So I guess I come back to what I asked counsel for the secretary. What authority do we have to undo favorable actions that took place after the board decision, the purported board decision that's on appeal? How is that consistent with our statutory authority to review adverse determinations and to review the record of proceedings up until the date of the board decision?
I think Cirillo allows this court to reach those, favorable actions, what I'll call them, because just as the facts in Cirillo where the board indicated that he wanted to reconsider the veteran's claim, that could be construed as a favorable action to that veteran that the Cirillo court said you cannot do without permission from this court. And the same is true for Mr. Kernz's case, in which those docketing letters could be construed as a favorable action, but needs to be done with this court's permission. And no harm will actually come to Mr. Kernz if this court were to assume jurisdiction and remand the case to properly docket and to properly comply with 20.104C, because docketing that in accordance with proper authority will still give him the exact same docketing date that he has.
Even if he might have gotten a board decision tomorrow and our opinion may not issue for a year and a half, your position is they cannot issue a board decision Isn't there another option here that the veteran could just withdraw his appeal here and allow the proceedings down there to go forward? And he's already gotten the relief that he asked for. Docketing his appeal. They said it was untimely. The board admitted the mistake. They docketed it.
Well, just as, and I guess this relates to a little bit of Judge Allen's question, it's speculation to assume on both sides of that coin that the board will consider the arguments and evidence that he submitted in May, or that it will be precluded from considering.
Speculation, how do we have jurisdiction to address it? There's no harm yet.
Oh, well, I mean, if he received a decision, it may or may not have considered his argument.
Sorry to interrupt. Regulations are waivable, right? I mean, they're claims processing rules that are completely waivable. You have in writing an absolute complete waiver of whatever prohibitions or whatever regulatory prohibitions are in that. Why would that not suffice?
Well, what we don't have is a guarantee that he will, that his arguments and evidence will be considered. And that's what I was.
What does it say in writing?
It says his appeal has been docketed, Your Honor.
Okay, and that means they're going to consider the evidence.
Well, under Davis v. McDonough, the arguments and evidence was submitted late, and the board didn't consider it. So if this is considered outside that 90-day evidentiary window because it was submitted during the middle 90 days and not the first 90 days or the last 90 days, then it won't be considered. And that medical opinion evidence, the arguments could be critical in getting those benefits granted. If he gets a decision tomorrow and it denies his claim because it didn't consider that evidence, nothing has been done for the veteran except docketing and a preclusion of his arguments and evidence as not submitted within his 90 days.
So if right now, today, here on YouTube, Secretary's Counsel conceded, yes, we'll give you 90 days. That's completely mooted out. Otherwise, you'd rather take your chances that the board decision comes out before we issue an opinion. It's completely favorable to you, and your argument is today it's void.
I believe it's void because of Cirillo, Your Honor.
Well, we've the en banc court here. We could scrap that whole thing today.
That is fair.
We could do it by show of hands, maybe.
Fair point, Your Honor. But Mr. Kernz does maintain that his harm is still maintained despite Cirillo's presence or absence, because of the confusion created by the board's post-notice of appeal actions regarding the 90-day evidentiary window. So even if Cirillo is overturned, because he still has harm in that he has no assurance that the board will consider his arguments and evidence, overturning Cirillo doesn't moot out his case.
How old is he?
He's in his low 70s, Your Honor. I don't know the exact.
Do you have any good faith estimate of the age panorama of members of the putative class? Same as Kernz?
Most likely the same, Your Honor. The ones in our firm are roughly the same age. Some are in their 60s.
And do you have an estimate of how many people are involved? I heard from the secretary that it's this tremendous activity that they got to engage in.
We believe that there are approximately 1,200 involved based on the secretary's conceded error rate, just with the claims in our firm alone, but also given the secretary's revisions to the letters that Mr. Kernz received, the March 23rd, 2021 revisions still do not comply with Section 20.104C. So the board's continued behavior is still creating class members because their appeals are still being denied without fair process and in violation of 20.104C. So the number continues to grow. We don't have the exact number, but I brought with me similar letters to the ones Mr. Kernz received that we received last year. And the new revised letters, as Your Honors alluded to before, they don't allow the opportunity to request a hearing or to submit evidence. And they actually state that if the claimant doesn't respond in 60 days, then the decision becomes final, just like the pre-revised versions. So without full notice of appellate rights, without an order, etc. So the board is still extinguishing these appeals through these letters, just as it did with Mr. Kernz. It's just now provided a 60-day appeal period in which before they become final.
These are letters from that were sent to clients of your firm?
Yes, Your Honor.
What did you do when you saw them?
We're attempting to take action as best we can, Your Honor.
For example?
For example, responding to the board within 60 days, filing briefs, doing what we can as advocates.
So that they could recognize their mistake and take corrective action.
We're doing what we can. Sometimes the board just maintains their closures.
It seems to me that Cirillo shouldn't be a roadblock to the VA taking action to favorable action to rectify obvious errors, whether you've filed an NOD or not.
I certainly agree the board should be encouraged to correct its errors, but the burden in which to obtain permission from this court to do so is extremely low. And it provides the veteran with input on whether the actions the board wants to take are actually favorable or not. And it provides judicial overview to ensure that whatever JMR or settlement agreement or termination is in accordance with the law. None of those things get to happen whenever the board takes unilateral action that it decides is favorable to the veteran. The veteran might completely disagree, and there's nothing he or she can do about it. But with Cirillo in place, the veteran does have a say, does have a seat at the table in which to agree. And if the veteran agrees that the action is favorable, the parties file a joint motion and the case is disposed of. It's as easy as that. We do it all the time.
Can I ask you some questions about whether the March 2020 letter is in fact a final board decision? In Tyrus, the Federal Circuit in their 2013 decision held that predicating appealability on the board's unambiguous instructions as to whether a denial is final and appealable provides clarity and is not incorrect, and then relying on a clear appealability statement by the board avoids premature attempts to appeal the unappealable and failure to appeal the appealable. Was the Federal Circuit trying to create a bright line rule that when we're trying to figure out if something is a final board decision, we look no farther than whether the board said it was? And if not, then what does that language mean in Tyrus about a clear appealability statement from the board?
It's important to note in Tyrus, the focus of the Federal Circuit's analysis is whether the veteran understood the decision was final. And the Tyrus court indicated that the veteran understands the finality of a decision when it's his or her responsibility to take further action to appeal. And the March 2020 dismissal very clearly indicated that no more action was going to be taken by the Secretary, and that it was indeed Mr. Kernz's responsibility to take further action to get his appeal heard. And so under Tyrus, I don't know that it's necessarily a bright line rule, but it's more of an analysis as to what's the impact, what's the message being conveyed by the board's actions. And
what do they mean by the clear appealability statement, and that there has to be unambiguous instructions from the board that it's final and appealable?
Well, I believe that statement is made in context of the notice of appellate rights, in which the Tyrus court also stated that the notice of appellate rights is just another signal to the veteran that no more action will be taken by the VA on his or her case. And so it's not a bright line rule that attachment of appellate rights is absolutely required or critical for a decision to be an appealable decision, but yet just another signal to the veteran that the burden has shifted.
And is there any such signal in the March 2020 letter that letter could be appealed to the court, that the board viewed it as a final decision and that it could be appealed?
Yes, Your Honor. So that letter, it says that it makes an application of law to fact, so it makes a decision and then informs the veteran of what to do if he disagrees with that decision. And
with
the veteran,
the letter.
Excuse me.
It says with the letter. If you disagree with the letter, it doesn't say with the decision.
Oh, well, I'm referring to it as a decision because Mr. Kernz views it as an application of law to fact. There is a law that establishes when an appeal can be filed. there are facts, and when the appeal is filed, they applied those lot of facts and created the decision that the appeal was ineligible and untimely.
Why not? Why didn't you challenge that through a petition? I mean, it strikes me as such a, like going through mandamus is such an easier, cleaner way to do it because, you could get right to the issue of whether the secretary is going to address this. You could join a class much easier without the sort of score issue of trying to link up, appeals in a class. Why not do that?
Well, because Mr. Kernz's position is that was a final appealable decision. It was adverse to
Sure,
him.
but you could just you can literally bypass that whole issue of, jurisdiction and just get right to the timeliness and relief and all that stuff.
Well, I believe this court held in Garner-Dixon that when there is a direct appeal available, a writ is not appropriate, Your Honor. So if Mr. Kernz views this as a final decision that is subject to appeal, a writ would not be appropriate under the court's jurisprudence. We also didn't necessarily view this as an extraordinary circumstance. This is a pattern of behavior by the board to terminate these appeals unlawfully by violating Section 20.104C. It's not an isolated incident that I guess would lean more towards a writ circumstance. But because it's a final decision, Mr. Kernz thought writ wouldn't be necessary.
No means no.
Correct, Your Honor.
Mr. Locke, I just wanted to close with one easy yes or no question for you, assuming my colleagues don't have any further questions. And that is, okay, yes or no. If you take an isolated statement from Tyrouse without regard to the context of that case, and you make it a law that we follow, is there a danger that the board will or can omit a statement such as the one Judge Meredith was referring to, just omit it from a decision and thus avoid judicial review?
Yes, Your Honor.
Thank you. You have more?
I do have another question. But as to Judge Toth's point, if the board did that and refused to issue an appealable decision, could you file a writ? A petition?
I see I'm out of time. May I answer your question, Your Honor?
Yes, you may.
I do.
Thank you. If the court concludes that's not a final appealable decision, the secretary has taken the position that, or the board has taken the position, no further action will be taken without further action on behalf of the veteran. And in those revised letters, the board has said this matter is considered closed if you don't respond in 60 days, and that is unlawful. So in that circumstance, should the determination be that these are not final appealable decisions, then I guess a writ is our only other option, Your Honor.
So I just wanted to, my final question be what I asked the secretary. What is the more veteran-friendly approach here? We know VA made a mistake in these letters, obviously. But if we call them final board decisions, does that come with it that an appellant now has to file the formal process of either reconsideration, getting it vacated, appealing, as opposed to if it's a letter and may have no legal effect, VA has not yet adjudicated properly timeliness, then there may be more informal ways, such as what you were describing earlier in your other veterans cases, to handle this. Which is the more veteran-friendly approach in handling whether we call this letter a final board decision or not?
The more veteran-friendly approach is to determine that these are final appealable decisions and to certify a class, because without that action, all of these appeals will be closed. And that is not a veteran-friendly approach because
Sorry, continue.
Because their appeals have been extinguished and they have no other recourse because they have not been notified that their appeals were closed unlawfully. And without the Secretary's efforts to go locate these people and inform them that their rights have been violated, those people are being disposed of as if they don't matter.
But are you, by elevating the letter to a status of a final board decision, that would apply across the board to anyone who received a letter who wanted to maybe just call and say, I think you made a mistake. And now are they going to be forced into this formal process of having to seek reconsideration or appeal to the court, something that could have been handled through a phone call?
Well, I don't want to overgeneralize the statement, but there are differences in the types of letters Mr. Kernz received, the classes received that extinguish their appeals, and other types of notice letters that do comply with 20.104C. Those notice letters that are in compliance with the regulation indicate that there is a potential jurisdictional defect that will be ruled on later, that no adverse action has been taken, but will be taken in the future after the opportunity to provide arguments, evidence, request a hearing, etc. And so the I guess concern that any letter would be elevated to a decision, I don't think is a completely accurate concern, because it is only the letters, the decisions from the board that terminate appeals, that deny rights, that should be considered these decisions. And the board knows how to issue letters in compliance with 20.104C. It does it all the time. We receive many of them in our firm. It's just choosing not to do so in these situations, and that's the problem.
So to that point, let's assume for a minute that all of the criteria for certifying a class were met. Why, in your opinion, would it be superior to this court issuing a precedential decision that could spell out exactly what needs to be in the VA's letters, etc.?
A great question, Your Honor. I think a class is superior relief in this situation because it could compel the secretary to locate those adversely affected men and women who have received these decisions, because the secretary doesn't want to do so now out of these concerns that it was too burdensome. And so a precedential decision just determining that these are final appealable decisions doesn't require the secretary to locate these decisions. It still treats this as a quasi-class that is an opt-in class, as opposed to a 23B2 class, which is an opt-out class, which requires the secretary, because all these veterans who receive these adverse decisions are now members of the class, requires the secretary to locate them and remedy them. That being said, I do think that the court does have the authority to enter class-like relief should it choose to not certify a class. So if it does determine that it can order the secretary to take action to locate these other adversely affected men and women because they have also received final board decisions, then that would be appropriate, Your Honor.
Would Mr. Kernz be part of that class action, in your opinion?
Yes, Your Honor.
Let me ask if I understood clearly what you were saying. Because you feel it is your opinion that Cirillo applies. Therefore, every action taken by the secretary is null and void, beginning as of which date?
As of the date the notice of appeal to this court was filed, Your Honor.
2 weeks after Mr. Kernz received his letter.
Yes, Your Honor.
And so everything after that date is null and void, doesn't mean anything because the secretary didn't have jurisdiction.
Correct, Your Honor.
So where would the case, his appeal be if we agreed to that position? Where would Mr. Kernz be in the appeal process? Would he start from scratch, from March, where he was at the point in March of 2020, or what?
Well, two things would need to happen. If this court determines that Cirillo applies and that the board's actions were null and void, then it would remand for the board to comply with Section 20.104, docket Mr. Kernz's appeal, provide him with a clarity on his 90 days or a new 90 days. And that actually doesn't result in any harm to Mr. Kernz. At least in my firm, we still have cases from in which 10182 notice of disagreements were filed in 2019 that still have not been adjudicated. And his appeal would be docketed January 2020.
Point of view, in your firm, you've already submitted a number of documents or you've complied with certain things. Have you? I think you indicated you submitted some evidence here and
arguments and evidence. Yes, Your Honor.
Would you have to redo that, or would
yes, Your Honor.
You'd expect the board to provide instructions regarding that?
Yes, Your Honor.
And you would do that and submit everything? And
absolutely, Your Honor. And in practice, the board requires that. at every hearing or 90-day lane. It doesn't matter if it's 10,000 pages of medical records that were received between the notice of appeal between the decision from the regional office being appealed and the 10182 with the 90-day lane. Even if those 10,000 pages of medical records are in VBMS, the board requires you to resubmit them within the 90-day window, or else it will not consider them. The board thinks unless it's within that 90 days, it is completely off the table.
So in your opinion, none of this will set Mr. Kernz back very much?
Correct, Your Honor.
Thank you, Mr. Locke.
If I can't get my position really quick, the timer wasn't started, so I'm sorry. Mr. Kernz does respectfully ask that the court deny the Secretary's motion to dismiss and to certify class relief in this case. Thank you.
Thank you. And Mr. Esterman?
Thank you, Your Honor. I know we've been here for a while, so I'll try to keep this brief. I just have 4 quick points in response to my friend's arguments. The first is just this idea that there's been a favorable determination here made, and this court has long recognized in cases like Mariano that it definitely doesn't interfere with favorable findings or favorable actions before the court. And so I think the most veteran-friendly situation was to maintain Mr. Kernz's position on the docket and not to find anything null and void with respect to the actions that have been taken. With respect to the concern about the 90-day window and submission, I understand that's a genuine concern, but I think that concern is best positioned with the board as to the merits of any appeal before the board that's been docketed. My third point is to Judge Meredith's comment about Tyroos in 2013, which I think is downstream of the Fed Circuit's decision in 2000 that said that the final board decision contains an order specifically granting or denying relief. And I think that is kind of the lane that Tyroos in 2013 continues to follow. And again, the letter here didn't contain that type of clear directive allowing the veteran to know that his benefits have been denied.
But Mr. Esterman did in the very case that you cited, I don't know how to, you said the name better than me, Laugen?
Yes, Your Honor.
Specifically hold that the omission of that, a board's order denying relief was, even if an obvious clerical error, because the board decision made clear that it was denying the veteran's claim in that case, that it was not correctable by the board without the permission and approval of this court.
I'm trying to recall the specific facts in Laugen, but I think at least in Laugen, the distinction would be that there was, again, what appeared to be no dispute as to a final decision of the board. I think there was just a concern about what the order contained with respect to a claim. And so I think that would be the distinguishing factor between this case and Laugen.
But the point I'm exploring with you, though, is that if there's a final decision, the omission of the operative order language doesn't render it non-final. And secondly, the correction of that error, if it's otherwise final, is impermissible without the permission of the court.
Yes, Your Honor, assuming that there is a final decision of the board, which I think I've made myself clear, so I won't repeat on that front. And my last point is, and my friend was talking about the clients he has at his firm. There are different versions of the letter that's going out, and I don't mean different versions in what previously existed and what the board is now using. I mean that some claimants are differently situated in that, and this is just for clear, it doesn't speak necessarily to the merits. There's pure AMA appeals, 10-182s filed. In this case of Mr. Kernz, he was in the legacy system. He received an SOC. He opted into the AMA system with a 10-182. So he had a foot in both systems to pursue an appeal to the board. And so there are different versions of this letter. So, when you're thinking of the scope of the specific letter at issue here and other impacted claimants, there is differences in the context of the procedural circumstances of some of these veterans. And I think it's just important to be aware of that distinction. There's no further questions. We respectfully ask the court to dismiss this appeal and find the request for class action moved. Thank you, Your Honors.
Thank you, Mr. Esterman. And the court thanks both parties, both the Secretary and the Appellant's Counsel, for their arguments. And the case is submitted for consideration, and we are adjourned. And we will come down and greet counsel.
All rise.